Good afternoon, everybody. Welcome to today's webinar, Contracts in China. Today's webinar is tailored and focused towards Australian legal professionals needing to navigate their customers through Chinese and through the contracts in China. Today I'm joined by David Bennett, our IP counsellor in China. Good afternoon, David.
Hi.
And we also have Wei Xin from Looming International, who will also be presenting today's content.
All right, thanks, Casey.
Thank you.
Yes, so I'm Intellectual Property Counsellor here at the Australian Embassy in Beijing, and we're sitting here in the Embassy in Beijing right now. This is IP Australia's first overseas position, and I've been here since December of 2016. The position in general terms is to help Australians protect their IP in China. So I do outreach work and give assistance to businesses on individual inquiries. And I also support our government level engagement with China and guide our IP policy in relation to China. I give guidance and support on individual inquiries, but I don't give any legal advice or legal services. So I always steer people towards experienced practitioners, be that an Australian IP attorney or a local Chinese lawyer, depending on the nature of it. Our last webinar on trademarks was our first event directly from China, so we learned a lot from that. So in response to your feedback, today's webinar is quite focused. We have just 15 slides, which you will be receiving later. So we'll speak for about 40 minutes now and then go to questions at the end. As Katie said, please stay on to provide feedback on that survey. We do read it, we take it very seriously, and we welcome your suggestions for what we could do better, future webinar topics, and other ways we can support you better. But ultimately, that's what my role is about, supporting Australians, including yourselves. So in my time here in Beijing, I see two issues come up very frequently. The first one is people failing to register their IP rights in China. So that's the number one thing I'm talking about. Number two after that is probably actually contracts. People failing to protect IP in China and just contracts in general, letting themselves down with poorly drafted contracts. It's been an issue that comes up again and again. I've been wanting to assist people on this, but I'm not a China lawyer. I'm not expert in this. So I've invited someone in who is, Wei Xin. Wei Xin is co-founder of Looming International, which is the international business group of the Beijing Looming law firm. She's in charge of cross-border transactions. She's worked exclusively on China-related cross-border transactions over her legal career. She was in Australia for 10 years, including at Baker McKenzie and Mallesons, before returning to China in 1995. And it's quite mind-boggling when I think about the changes that would have happened between 1995 and now 2019. So I'm very glad to have someone so experienced to talk in depth about contracts. So thanks for coming in, Wei Xin. So we're going to go to the slides. I'll turn off the video for that, so you can concentrate on that on the slides.
Oh, that's okay. Thanks, David, and good afternoon, everybody. It's really great to be here today to talk about my favorite topic, China and China contracts, and share my experience with professional colleagues. I know that there are friends and business colleagues in the audience, so thanks very much for joining us. Before I move on to talk about today's topics, I just want to give you some background so you know why we say China is important or China is very different, and you've seen China's gone a long way. When I came back in China in '95, we had two parallel legal systems, one for domestic transactions, one for foreign-related ones. And for foreign companies or foreigners dealing with China, all you need to do is the foreign-related laws like a joint venture contract and a wholly owned foreign subsidiary law in China. And you don't have to know about other things. For contract, we had a separate domestic contract law back in 1993, and we had foreign-related contract law in 1985. But in 1999, we had the unified contract law. So being a lawyer, being here and seeing all the changes, it is quite exciting. At the same time, it is quite challenging because you really need to know the law before you can advise the client. Today's topic, when we talk about China, I can only say I'm covering mainland China only. That's where I am from. I'm not talking about Hong Kong, Macau, or Taiwan because they're totally three different legal systems. I've seen people ask me, you know, when we draft Chinese contract, to say, can you throw in Hong Kong or Macau or Japan or Hong Kong, Taiwan? And I said, no, you really need to deal with those three jurisdictions separately. It is Great China, but we talk about China alone. Now, why China contract is very important? I can give you so many reasons, but they're just a few. And China is the important trading partner of Australia. And I think David reminded me that China is top 1 for Australia, and Australia is probably top 4 for China. So that goes how important it is, China and Australia. And China is a favorite destination for trade and business missions. I've seen many trade missions coming from Australia. It can be Queensland, it can be New South Wales, and any part of Australia. And they come quite a few times a year. China is also the favorite place for international expos and trade shows. Just give you some figures. In 2017, for Beijing alone, we held just under 800 trade shows for international business. So that's quite a bit. So people do come to buy things, to sell things, and have things made in China. But the core of those activities, they're the contract. That's what we're talking about today. Some contracts seem pretty good works, and many didn't. So when I first came back, I saw big companies come to China. Now we see smallish companies, medium-sized companies, family-run business. Some are ready for China, some are not ready for China. But they all have to have a contract to deal with Chinese companies here. So as far as I see, sitting here, there's a real demand for real information on China, Chinese business culture contracts. But this information not very easy to get, and sometimes what you get might be slightly out of date. Being here, I often hear people complain about China, but I must say that I think at least probably 50% or 60% of complaint, China is not a problem, but the way we deal with China, or engage in China, is the problem. So if there's a lot of lawyers, in-house external counsels on the webinar today, I would say it is quite challenging for us working in dealing with cross-border contracts work. And it is, unfortunately, I have to say, good practical legal advice is not easy to get. And today, in the next probably 30 minutes or so, I would touch upon the following issues: why China is different, why due diligence is very important, why China's language contract is important, and what's the practical choice for law and dispute resolution issues, and how what we should do to execute the contract correctly, and what's the limitation of having a confidentiality agreement or NDA, and why Australian style contract don't work that well in China, and what's the practical difficulties with us using Australian templates here for China deals. And if I had time, I would cover specific issues for the following contracts. One is NNA. The full name is non-disclosure, non-complete, and non-circumvent agreements. And then distribution agreements, purchase agreements, and IP licenses, and their practical issues. Now, why China is different? The first point is China is civil law country, it's not common law. That explains why it's different. And court judgments usually not binding at all unless it is the judicial explanation or decision of the Supreme People's Court of China, which is the highest court in China. And China has a centralized legal system, not a federation. So you look at law, it's law usually published by the state, by the government body at a state level, not city level. The cities or provincial government have the right to delegate authority to public regulations within the big legal framework. For lawyers, we like jargon, but as you see, I've listed a few jargon there. They don't really work in China when it's equitable remedy, because we're civil law country, so we don't have equitable remedies. Time is of the essence. I've seen that time and again. but we don't really have that in Chinese law as a legal concept. So if you want to tell a Chinese party why time is so important, you need to spell out in detail in the contract rather than leaving it in the future. Even though we translate the contract in Chinese, but it doesn't mean that the Chinese really get it. So it's quite important for us to spell out. In consideration of, again, civil law, not common law, so we don't need consideration, we don't need to sign a contract. Contract is contract, sign as contract. Without prejudice, that doesn't work in China, so you can throw in this phrase, but you don't really get it in China. Escrow accounts. We don't have the typical escrow account in China. We have something called supervised accounts, which requires the opening of the bank account with at least 3 parties, the bank, the 2 parties. There are a lot of conditions there. So if you don't get the outside agreements, you probably can't draw funds from the escrow account at all. So please try not to use that account in China because simply it doesn't work. You can probably try to open an escrow account for big transactions in a place like Hong Kong, but it's costly. Now, rule of evidence and court procedures are very different in China. To start with, almost all evidence from outside China need to be notarized and legalized. For people I've been working with, you probably remember when we say we need to start litigation in China, the power of attorney need to be notarized and legalized in China. The evidence need to be notarized and legalized outside China as well. That takes time and can be quite costly. Evidence in China. If you want to say somebody's copy your products, you can't just simply send somebody, your colleague, to go and say buy a product and buy the sample. Let's see what's happening. You can't introduce that sample to the Chinese court. You will have to notarize the purchase of a counterfeit product in China before you can use that in court. Affidavit doesn't work. Chinese court heavily focus on or rely on evidence, and evidence have to be properly brought to the Chinese court.
Just a quick note on notarizing and legalizing evidence from Australia. DFAT on the Smart Traveller website have a section about how DFAT can authenticate, legalize documents, and then the Chinese embassy and consulates in Australia can then also authenticate that, which will be required. So the Chinese embassy has information on that. The DFAT Smart Traveller website also has information on that procedure.
So basically 3 steps. You start with Australian North Republic, and then you go to the Foreign Affairs, then you go to the Chinese embassy. So in my experience, it takes at least 3 weeks to get that process completed. For Chinese procedures, because it's civil law, we use inquisitorial system, not adversary, so we can't have a big debate in the Chinese court unless you're asked to talk. Foreign exchange is very important in China. It affects every single transaction. It can be a small purchase agreement, it can be a trademark license agreement, it can be sale of shares and whatever in China. You really need to consider foreign exchange implication. Otherwise, it can affect your chance of receiving money from China.
Yeah, so this is China has controls to restrict the outflow of capital. So it is just simply very difficult to get money outside of China.
Again, here when we talk about, I probably say 60% of people complain about China does not issue. Something I can share with you is because of foreign exchange control issue, if you don't sign the contract properly, or if you didn't set up the company properly, you can't bring dividends out of China. So it doesn't mean China doesn't allow you to do it, you just have to do it properly, so the money can't flow out of China. Chinese companies, I've seen so many contracts coming from either Australia or other part of the English-speaking world. They only include the English name of the Chinese company. In China, Chinese companies don't have official English names, only Chinese name count. So if you don't want to have the contract translated in Chinese, the most important thing is you need to include the Chinese name of the company in the contract, so you can correctly identify who they are. We also now have introduced something called social credit code. It's similar to Australian company number. So you could include the Chinese name plus the Chinese social credit number. You can identify the Chinese party. Due diligence is very important, no matter for small deals or big deals. To me, the first thing to start with due diligence, you got to see who you're dealing with. Is that a real company? If you don't do that, you probably end up dealing with a company who doesn't exist or the wrong party. And that's really important. I don't quite understand why people are very reluctant to do due diligence. They sometimes come to me already have the contract or have problems, and the first thing I do is get on the night to check the company. And sometimes I find the company doesn't exist, or some company have totally different names. So then my question is, who are you dealing with? And the question, I don't know. I found this person from either the WeChat or from the DD or something like that. It doesn't work. You really need to do due diligence. Get to know the company as soon as you can, so you know if the wrong party, you walk away from it. When you do manufacturing, I think it's important to not only to check the company. You can do a company search in China quickly and cheaply, but everything you find is in Chinese. There's nothing done in English. So if you want to know who this company is, if you want them to manufacture goods for you, I would say you probably need to come to China, walk around the factory, and have a look whether this is a real factory or this is somebody else's factory your Chinese suppliers borrowed. Just to share with you some experience, and one of my clients deal with this big Chinese company, and they said they need them to comply with Australian safety rules. So they went to the factory, did a great tour. They had this gentleman who spoke great English, walking them around and talk. Finally, when asked one question by passing, they found that he didn't work for the company at all. He was invited to be there alone on that day to give a presentation to the Australian company and to accompany them. So he's a professor from a local university. There you go. Another thing is we're talking about send me the samples before I sign the contract. That's the right direction, the first step in the right direction, but sample doesn't always work. Sometimes I know people make samples specifically for you. Doesn't mean that they can make in big quantity in the factory. So you need to see the factory, make sure that you're dealing with the right people before you sign a contract. In China, sometimes company need to have a special permit or qualification to make products. So you need to see, do they have that or not before you sign a contract with them. A commercial reputation important. You probably need to check the track record before you want them to be your distributor in China. Again, a word of caution, all information in China in Chinese. So most of them can only be available in China. So you need to know who you're dealing with, who you talk to before you know whether you get the right information or not from China. Chinese language, to me, it is very, very important. It's not because I'm Chinese, I read the language. It's really important that you let the other side know whether they are agreeing to the provisions in the contract. So the contract is not only just a document setting out the legal rights and obligation, it's actually a roadmap for future behavior. It happens quite often that you give the Chinese a document in English, you get nothing. They said, I'll probably come to talk. They didn't say they agree to the Chinese, to the English version or not. The moment we get the document into Chinese, they push back, say, no, I didn't agree to that contract. I didn't agree to that provision. Those, at this time, it doesn't mean they change their mind. It's probably they didn't understand the English version. So they're not to us. It's a matter of losing face. So why don't you do them a favor? Do yourself a favor by putting contract in Chinese, in their language they can understand. So we're all happy. The better, the earlier for you to know whether the Chinese is the right party for you, the better. Otherwise, you waste more time to get the contract done, and then you realize the Chinese can't deliver the goods, can't deliver the services, or they just don't have the right attitude, or they are not on the same level. So it's quite important to find that as soon as you can. Now, disputes. If there's a dispute, if you come to China courts, all the materials must be in Chinese. So if you haven't translated everything in Chinese, then you will have to get document translated by a certified or designated Chinese translator. They might be very good with what they do, but to translate legal documents is a big challenge. It doesn't mean they can't do it. Probably the quality varies. But if you have the poor translation, that will directly affect your rights at the court. So again, my advice is, it's very important to have control over the translation process. You have the translation done. If you can't get it done at the contract level, you should get it done before the documents are produced to the Chinese court. Our advice is always been, try to have a bilingual contracts, English and Chinese, and then both sides understand what's the contract about, and try to avoid using information only for Chinese version. This is happens quite often to American contracts. American court try to say, we provide you the Chinese translation, Chinese documents, but we only sign English version. So this is for you to use, for you to have a look. What do we mean? Do we just get them to have a look? But how accurate it is? And if there's a dispute, Chinese say, I only read the Chinese version, I don't understand English version. So it is quite important to make sure that we have the bilingual contracts. I've seen people fighting over a particular contract or particular clause. The Chinese, the foreign parties think they ask the China to pay in a particular way. The Chinese say, I didn't agree because that's what not said in Chinese contract. When I was asked to have a look to see whether there's any chance to go for dispute, I look at it, and there's a big difference between the Chinese version and English version. So the foreign party lost at least $150,000 and parties' relationship broken 100%. The practical choice of law and dispute resolution. If you don't remember anything I said about choice of law and dispute resolution, just remember one thing. A decision of the Australian court is not enforceable in China. So, of course, if you read the law or whatever, there's a diplomatic channel. But I have never seen that in my life, that Australian court's decision has been enforced in China. So please try not to do that. And for international arbitration, it is probably the most important way to go when there's a dispute between China and Australia, and China and another country over commercial issues. But there is a caveat. If the amount in dispute is small, it's probably not worthwhile to go to international arbitration. It can be quite expensive. If you decide to go to international arbitration, I would suggest consider Hong Kong and Singapore because at least half of the dividends will be in Chinese. And if you go to arbitration in those places, there will be arbitrators who are bilingual, so you don't have to have document translated because translation can be very expensive. I put out tips there for you to consider. It's basically Chinese law, Chinese court will work. Chinese law and foreign arbitration can work. And foreign law and foreign arbitration, unless that will work unless foreign law is permitted for Chinese contracts. Chinese law, foreign court, it wouldn't work. If you get Australian law, Australian judges to look at Chinese law, I don't think it's going to work. And also the same issue, Australian judgment doesn't work. It can't be enforced in China. Foreign law, foreign court is even worse. You wouldn't expect a civil law judge to consider the cases using common law concepts. And the last one is foreign law, foreign court. I probably need to put a question mark there. I know there are bilateral treaties between China and some European countries like probably France and Italy, but as far as Australia is concerned, there's no treaty between China and Australia for enforcing a judgment, a foreign judgment.
Yeah, I want to say this is not just a theoretical worry. This is something that I see again and again here working at the embassy. As Wei Xin said, the reason for this, China is not signatory to the Hague Convention on Recognition of Foreign Judgments. but it is signatory to the New York Convention on Recognition of Foreign Arbitration Awards, which is what gives rise to this difference. But one example that I've seen here, or that my commercial colleagues at DFAT are supporting, a commercial dispute between an Australian company and a Chinese company that provides for exclusive dispute resolution in the Supreme Court of Victoria. They've won a default judgment. The Australian companies won a default judgment against their Chinese counterparty in the Victorian Supreme Court, and they can't do anything to enforce it. The Chinese company only has assets in China, and the Chinese courts, of course, will not enforce the Australian court judgment. So in this case, it's over $20 million that are going to never be recoverable because of this mistake.
I think if you didn't put in exclusivity, you probably still have a chance to have a go at Chinese courts, but then Australian or Chinese court doesn't work. Chinese are probably more familiar with these kind of issues compared with Australian companies. Few times I've seen people say, they just say not Australian court, like a court from Denmark and Danish law, and we're asked to help to see whether we can mediate the dispute. So we sort of talked to Chinese a few times, and the foreign clients want us to threaten litigation. We told them it's not going to work. Then in the end, we have to say, look, we can take you to court. And the Chinese party look us in the eye and say, sue me. It's the court in Denmark. And at that time, I say it's quite embarrassing because we know it, but we know the Chinese party and fully understand the consequence. So please remember those tips when you advise your client or when you talk to your business team. How to execute a contract with the Chinese party is very important. In Australia, I've seen the contract say signed by 2 directors. That doesn't work in China. In China, this is the most important position of a company, which is called legal representative. This person has the statutory position under Chinese law. This person alone can bind a company in China. So if this person signed a contract, that will bind the company. If you fix the company seal of this company, that also bind the contract. So it is quite important to sign a contract for a Chinese way, and then you can sign Australian company Australian way. Try not to mix them both. Sometimes you deal with people, they are marketing directors or business development directors. The title sounds very impressive, but they don't have the legal right to sign a contract on behalf of the company. If the legal representative, if too busy or the company is really big, state-owned, for example, the legal right probably don't want to sign a contract. What you can hope for is after a power of attorney from the legal representative, ask the person to give the property power of attorney so he can sign. I know power of attorney is probably it's not used very often in Australia, so you wouldn't ask for that. But dealing with the Chinese company, Chinese are quite used to provide you with power of attorney, so ask for it. Ask to see the power before you agree that they can sign the contract. For us, the preferred way to get a legal rep to sign and also fix the company seal. I'll tell you why. I've handled a lot of disputes in China when I first came back. When we went to the Chinese arbitration or Chinese court, the first question the Chinese party would say, I didn't sign it. I don't know who used my company seal. I didn't authorize it. It could be the wrong seal. Somebody stole my seal. Of course, we can prove this is company seal. We sign, use email and everything you can bring to the court or arbitration tribunal. But you can, I hope you get to the meaning. You spend a lot of time arguing over issue, which could be resolved easily if you get the party to sign the contract properly. So remember the legal rep position. It is quite important. Even though the governing law is not Chinese law, you still need the Chinese company to sign properly. Otherwise, they can challenge you when you have dispute.
And I understand the legal representative, that person is identified on the publicly available information with the company registration and the scope of business. So due diligence will be able to verify who the legal representative is.
Yeah, that's right. Confidentiality agreements. Chinese companies so used to the contract, the concept now. So sometimes your company, I go to a meeting with the foreign party to meet with Chinese. The first thing say, do you want me to sign a confidentiality or NDA? So they understand. But as I put it there, it is not a substitute for good management of information. If you want to provide them with information, you sign the contract, you also need to manage the information yourself and actively. Interim injunction are not generally available in China. That's the time when you really need to rely on the confidentiality agreement. It doesn't work. You have to take action against them in China, and it can take a long time. And that time, they already use your confidential information. We are allowed to include liquidated damages provisions in the NDA. To me, it has more or less the deterrent effect rather than having a real effect, because if the amount of the liquidated damages is too high, either party, especially the Chinese party, can go to the Chinese court, ask the court to sign the signed amount or adjust it. But it's still a better way, or better than nothing, to put that in the contract. So the Chinese will get a bit worried when you say, if you use my information or you disclose information, I can sue you for damages, and the damages can be pretty high. To me, the most practical approach to confidential issues is you should conduct a due diligence to know who you're dealing with, whether it's the party you feel comfortable to park your sensitive information with, and also please try to give information on a bit-by-bit basis rather than give them everything, because you need to try to see what's possible. Sometimes can't come and say, no, it doesn't work, I have to give them everything. My response is, if you have to give them everything, are you ready for it? If they took the information away and did something wrong or breached the confidentiality agreement, what are you going to do? I think you need to be prepared for it before you go forward to release the confidential information to the Chinese party. We all like our own style contract, including me. But I might say the Australian style contract doesn't work that well in China. The first thing is it drafted according to Australian law, and as I mentioned before, it's common law system, and China is a civil law system. So a lot of concepts we don't have, like equitable remedies, time is of the essence. So it's no point to include those concepts in there. And also, many contracts I've seen from Australia is probably great for domestic transactions, but it doesn't have issues or didn't really address the issues correctly about cross-border factors. You know, we're talking about deliver the goods not next door in next days, but we talk about delivering goods cross-border from China to Australia, Australia to China. So if you want to use some provisions you already used many times, they might be useful for China's particular deals, but it's good to have a look first before you just say, there you go, that's Australian contract we want to use. Now, Chinese law is mandatory for some contract. For example, I mentioned share purchase agreement, or if you want to set up a company in China, Chinese law is mandatory. If you use Australian style share purchase agreements, draft in Australian way, then we say, okay, let's switch to Chinese law. And it doesn't work. You change the name of the law, it doesn't help. It's still an Australian style contract. So I think you need to be mindful why we use Australian style contract before we decide, you know, Chinese contract is not the way to go. Using Australian templates. I've seen lots of templates coming out of Australia. Some are good, some are not suitable for China. I guess you need to ask the question, what's the real purpose for us to use the templates? Is that the same deal many times, or is it the same contract for multiple jurisdictions? My response is, if it's contract for multiple jurisdictions, it just didn't work. There's a difference between Australia and the US, Australia and UK, and there's a big difference between Australia and China. So Australian contract template wouldn't work at all. Now, are we talking about we're comfortable with Australian contracts, so we don't want to take a risk of Chinese contract? I can give you, I think this is probably false comfort. I'll give you an example. I've seen a very big Australian contract. It works really well in Australia, very detailed for a lot of things, probably 900 pages long, and some provision they put in there, very detailed information. On the other side, they say delayed. But it's a delivering services in China. A lot of work needs to be done in China. Without work, it doesn't work. I explained the whole thing to the client. The client, the legal counsel, 100% understand and try to promote, sell the idea to the business team that let's use the Chinese contract. And after a while, the business team came back with feedback, exactly the word. No, we don't want to use Australian contract, Chinese contract. We feel comfortable with Australian template because we're using Australia so many times. In the end, when we go a lot further, because we've done few deals in China, we managed to persuade the legal counsel to have a China-specific contract, and we turn them into a China contract template. It works pretty well in the end. Another thing is, if we will try to use Australian templates, but we have to make a lot of adjustments to the contract to template to make it work, my advice is probably a lot better and cost saving to start a new contract and turn that into a China-specific contract and even a Chinese template. Okay. I just want to run quickly of the contracts I specifically mentioned. NNA. I don't know whether that's been sold very well in Australia or not. I heard it all the time. Client come over and say, I want NNA, I don't want NDA. And I say, what's the difference? Don't know. But everybody talk about, let's have it. I must say, it can't create miracle. It is, of course, it's broader than NDA. But the difficulty is, how do you prove it? How do you prove the Chinese are competing with you on the contract? How do you prove the Chinese tried to circumvent this contract you signed with them? So ask the question before you decide whether that contract is effective. Again, the most important thing is do a due diligence, find who you're dealing with, whether you can trust them with all the sensitive information before you sign the NNA with them. Distribution agreements. If I don't have time, I just want to mention one thing. Don't try to start with exclusive arrangements unless it's a compelling reason to do so. You don't trust them, you try them for a while before you decide whether you give them bids. To start with, you should start with non-exclusive and set a target. If they can't hit a target, let them go and try to terminate the contract and find out how you terminate. Territory, it should be mainland China. Remember what I said, not Hong Kong, not Taiwan, not Macau. Purchase agreements. One thing I want to say is probably UN Sales of Goods Convention. I've seen contract coming out from Australia in particular. They want to use UN Sales of Goods Convention as a governing law. It doesn't work. If you go to UN Sales of Goods, it is silent on formation of contract. If we don't know how the contract formed, we need to prove how it's formed. If you don't have a contract, governing law in the contract, you probably fall back with the international private contract, private law. That's probably defeat the whole purposes. Pay. How do we pay if we're the seller? How do we pay for it? Do we pay by TT? Do we pay everything upfront? Or we use, I would say, if it is a big contract, I would suggest you ask for performance bond or letter of guarantee. Chinese company has more switched on with performance bond. If they're the one who will provide you with services or goods, ask for it. Is that right? IP license. If we don't have time to run it, I would say two things. One is you need to check what IP do you have, and before you start drafting the IP license for dealing with Chinese. Many times I've seen the IP, the party want to cover are not registered in China. For IP license, foreign law is allowed, but the Chinese mandatory provisions can't be counted out if you use Australian law. One typical example is improvement. Improvement must be for technology, must be reciprocal. So if you say you can use my patents or know-how, but all the improvement will belong to me, it doesn't work.
Yeah, so on that, some people would have noticed earlier this year some of the provisions of the technology import and export regulations were repealed, provisions around, including around ownership of improvements. But there's still a judicial interpretation from the Supreme People's Court that specifically says you can't have unreciprocal transfer of improvements. So they still, like Wei Xin says, they have to be reciprocal.
One thing I sort of wish to add before I finish, if it's technology licensing, China has a category called technology import categories. So the first thing you need to check whether technology covered by your IP license is barred, prohibited. If prohibited, it can't get in China at all or can't get out of China. If it's restricted, it needs to get specific approval from the Chinese government. And if it's free, then you can get the technology into China, get it out of China without any difficulty. But that contract needs to be recorded with the particular Chinese government body. Okay, before we finish, I hope you can remember a few points. One is China is different. I think David and me have shown you how China is different. And I hope you remember the legal representative position, because you'll come across that issue again and again when you deal with contract, small or large. Choice of law and dispute resolution should be linked. Otherwise, we're going to have problems when there's a dispute with the Chinese party. One thing I've seen recently is people tend to move legal risk around on paper. I would suggest that that doesn't work. You like it or not, if your legal counsel, your clients come to China. If you're in-house counsel, your business team come to China. Everybody is keen on China. People want to sell goods, services to Chinese companies. If you want to come or you don't want to come, it's probably not your choice. They're here, you have to come with them. So I would suggest that we take a proactive view and try to control the process from negotiating, from drafting to the implementation of a Chinese contract. So embrace the challenges in China. China's here, you have to do the business in China. And if you have any questions, you are interested in Chinese issues, you can send me or David your email address. We'll put you on our mailing list. I promise you I'm not going to send a lot of bulletins out because I just don't have the time to do that. But if you're interested, please drop us a note. And thanks very much.
Thank you, Wei Xin. I just want to quickly go over some of my take-home messages. There's been so much learnings, so many learnings in this. It's so important to involve the China legal advisors early for the due diligence on the other party, but also just to work through the details of the contract as negotiations go on. So it's not just getting China lawyers in at the end for a quick look or a formality. You need to be involved early from the start. Due diligence will save you wasting time, effort, and money. It's so fundamental. Do not overlook it. For various reasons, civil law versus common law, translating Australian contracts is difficult and just unlikely to work well. It's better to actually just draft a contract for China. Bilateral contracts will help you ensure both sides clearly understand their expectations and commitments. Dispute resolution is absolutely critical. If you get it wrong, your contract will be unenforceable in China. Make sure your contracts are executed with someone who has the power to do it, the company's legal representative. Use the Chinese company name in the contract to identify them, because the English name is not the formal one. And if you can Ideally do both, get the company's legal representative to sign and the company seal on there. Confidentiality agreements, NNN agreements, are not magic. You can't rely on them too much. It's not a substitute for good information management. Finally, IP license agreements, you can't just have automatic grant back of improvements to the licensor. It needs to be reciprocal or it will likely be considered invalid. Those are some of the key things I've taken away. I hope you've all got lots of notes on the presentation. So Casey is going to moderate questions now. We've got 13 minutes for questions. So get into the chat box and send through anything you'd like to ask us about.
All right, thank you, Wei Xin. Thank you, David. We do have a couple of questions that have come through, and some really good ones that I was thinking myself. So the first question I've got here, there's been quite a lot of conversation about checking for the legal representative and making sure there's a legal representative signing that contract. And the question comes, is there a way to find out who the legal representative is of a Chinese company via an online search? Wei Xin, you may be familiar that in Australia we have a website called ASIC where you're able to kind of check the directors of companies. Does China have a similar online search or a mechanism in which to do some research from Australia?
Yes, we do. It is a government site. I can't give you the exact name now. It's a government site run by the Chinese, we call them AIC, the Authority of Industry and Commerce. They're the government body in charge of company registration. So if you search for them, you can get to their official website. You can put in company name, you get to the information. But unfortunately, everything's in Chinese, not in English.
And not just in Chinese, but some Chinese government websites in particular, or China hosted websites, can be quite hard to access from Australia. So we find some days, these work, some days you might have trouble getting on, in addition to being in Chinese.
Okay, thank you for that. The next question we've got here is, if a contract is drafted under Australian law with the mechanism for arbitration, would any avenue be available to challenge an arbitrator's decision in court in either Australia or China?
Arbitration should be once and final. So you usually, if we put it that way, most of the time the Chinese party might be the one who breached the contract. So if you have arbitration in places like Singapore, Hong Kong, you're going to enforce them. You have to enforce them in China. So the Chinese courts usually will enforce the arbitration decision from outside China, but they will only refuse it on very few grounds. One is the public interest. If, for example, the judgment, the arbitration award was done against the Chinese law, then that can be enforced in China. But one thing I sort of hope the Australian colleagues understand is, in China, enforcing a court judgment involves two processes. You got to apply to Chinese court, have that accepted, and then enforce it. Enforcement is a very tedious process and take a long time, very expensive. And by the day, you probably get an empty judgment because the Chinese party could have removed or transferred its assets to another company before you finally get to them. That applies equally to foreign parties and Chinese companies.
Okay, thank you very much. So the next question I've got here is that you mentioned earlier that for dispute resolution, international arbitration is recommended, but not if the dispute amount is too small. Could you please provide an indication if there is a threshold amount that people could work to?
It's not in the law. My experience, if it's under say 150,000 Aussie dollars or 100,000 US dollars, and I think it's probably not worthwhile to do it, because you talk about going to arbitration, you need the lawyers, you need to appear at a hearing, and that's very costly. The legal fee, I wouldn't say legal fee is 100,000, but it's probably you have to add in a lot of costs before you decide before you see the judgments. Like I said, if you have enforced it, it's probably take a couple of years before you finally see the final judgments.
Yes, so the other option touched on by Wei Xin was the Chinese courts, actually going directly for dispute resolution in Chinese courts, which can potentially be weaker or cheaper.
I think probably more practical to go Chinese law, Chinese court, because you can take action here against the Chinese party. It's probably faster. It probably doesn't cost that much if you do it in China. But again, you have to enforce it. No matter how you do it, enforcement can't be avoided. Maybe I can take it the other way. Going to court is one thing, but the better way to do is probably manage your contract properly, get the right contract done, manage it, and try to stop the contract, stop the damages, and even walk away from it before your damage is become huge.
Okay, thank you. The next question I've got here says, with improvements being reciprocal, does that mean the improvements can be owned, but they have to be licensed to the Chinese company? Or does it mean that the improvement is owned by the party which creates it? I think that's referring to the IP slide that you were talking about.
Yeah, I think who improve it will own it. So in the Chinese sense, we give the license to use our technology and they improve it as part of the process. They will own it unless you put some input, you work with them. And if they own it, you should try to get a license back free of charge.
Okay. The next thing is with respect to the free trade agreement. Does the free trade agreement with China assist in smoothing out the legal formalities in China for Australian business entities?
So the legal and the IP section of the China-Australia Free Trade Agreement mostly reaffirms commitments to international treaties and conventions like TRIPS, the trade-related aspects of intellectual property rights. So it doesn't give any sort of new legal frameworks for between Australia and China. So there's really no special things in terms of the legal sense created by the free trade agreement.
I've got a question here with respect to seeking support for startup businesses trying to access China. David, could you comment on what services and supports the Australian Embassy has, and probably IP Australia and Austrade for that matter, in supporting Australian startups to enter the Chinese market?
Sure. There's a lot of things. You can go to business.gov.au to look up more information, grants and funding that may be available. Austrade do a great job across the Greater China network. You can go into the Austrade state offices in Australia and look at the support they can provide. Different states and territories in Australia can also, that local government level, so Melbourne, Victoria, New South Wales, Queensland, they will have representative offices over here in China, and you can tap into that support as well. There are other organisations, for example, AsiaLink, which can help with doing business in China. There are startup incubators with a particular Asia focus, for example, Haymarket HQ in Sydney. So there really is a wealth of resources out there, and also further information on our own IP Australia website, ipaustralia.gov.au/China for all the China-related information.
Thank you, David. So one of the questions, jumping back into the contracts aspect, so what are the major differences between Australian and Chinese law relevant for contracts? For instance, say a contract to sell widgets, identical except the customer, sorry, forgive me, there's a few. Identical except the customer wants Chinese law and the Australian supplier wants Australian law. What risks do we have if we're accepting that in at the Chinese law?
I think for Chinese contract law, we actually have a fairly comprehensive and good contract law. So for me, I'm quite comfortable to recommend Chinese law. Of course, you sit in Australia, you sit, I don't feel very comfortable, but if you go through Chinese contract law provisions, most of the provisions are in there. Probably briefly, but it covers most of the issues.
Thank you, Wei Xin. Are there any rules which allow companies to shift assets or funds away, which will affect the recovery of damages?
Was it Chinese companies shifting assets or
Yes.
evading?
For example, they will just
when you apply for enforcement, you could apply for we call them attachment to property or assets in China. You can apply to the court for that, but you will have to provide with the details where the property are situated, whether you can freeze the bank account of the Chinese party, but it's getting harder and harder because the control of information. You can't just go to the court and say, I want to freeze their assets, but the court will ask you, where is it? So you're the one who have to come up with the details, and also you will have to come up with the bond as well for the request.
Thank you. The next question we have is, in Australia, we have several, I suppose, templates that are available from government and law firms when doing contracts and things like that. Are there any templates available for Chinese contracts which you might be able to recommend? Thinking about, I suppose, early stage businesses might find these useful and a handy kind of information point.
I haven't seen government publishing the template for Chinese contracts, but there used to be a template for Chinese joint venture formation contract, because there's something very specific China. So people use that.
So some of the feedback we've got from the research institution, higher education sector, has been that they would really value a non-disclosure agreement template for China. That's something we're looking into at the moment. So check back on our website over the next couple of months.
Certainly, if you are subscribed to IP Australia's newsletter, when that information is loaded to the website, you will get an email obviously advising that there is a new package of work that you can access from there.
If I can add in one, for contracts, you probably really need to talk to Australian lawyers. Don't just come to China, because I think it's not working. At least the lawyer can point you to the right directions or ask the right questions.
Yeah, and even if you have some sort of template, you'd want to be getting legal advice on how to then turn that into a workable agreement, not just using it as is.
All right, the last question that I have before I close out today's session, can one rely on the Chinese company name printed in Chinese on the Chinese patent publication as the official name?
The Chinese patent publication.
So if the name of the company was in Chinese on the Chinese patent documentation, rely on that name?
I must say I put a question mark there. For me, no matter what we do, the first thing I jump on the government website, or me or my colleagues check the government website to see what's the name of the Chinese company, rather than just rely on anything, either their own website or somebody else's website, because that government body is the one in charge of company formation registration. They have all the accurate record of the Chinese company name. So I would say that's the starting point.
Excellent. All right, David and Wei Xin, thank you so much for presenting this module today.